think everything is working okay now. All right. So this is.
Mr. Sagat.
This is case number 216282. This is Ramon Pratt versus Robert River Walk Hotel. The matter is before the court on the defendant's motion to set aside a default judgment. Do I have the parties on this matter? Any attorneys first for the record? All right. Do I have Mr. Pratt or Riverwalk on this Zoom? Anybody?
Yeah, Judge, the 130 case is the one that was being dismissed.
I'm sorry.
Your 940, that's not the one. I'm sorry.
Okay.
The next case.
This is not the case.
No, that one right here, that's 282. The Pratt case, no, that one, no one signed it on that yet.
Okay.
905.
So the court is calling now case number 21-68767. This is Jefferson Capital Systems Incorporated versus Dion Holmes. The matter is before the court for a status conference. The matter has been filed as a claim regarding a breach of contract, it appears. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. May it please the court. Suzanne Strickhartz, STRICHARTZ, P44018 on behalf of Jefferson Capital Systems, LLC.
All right, thank you, and good morning to you, and thank you for your patience this morning as we've wrestled with certain technical difficulties. Do I have on this Zoom Dion Holmes? Dion Holmes, please.
You know, Judge, he may not have appeared. We mailed out a dismissal with release language to him. That went out to him, I think, about a week and a half, 2 weeks ago. So he may just be receiving it. I'm wondering if it's possible to push out the status conference, Judge, 30 days to allow him time to review the proposed dismissal and release and get it back to us.
All right. So if you're confident with the dismissal, the court will go ahead and sign the dismissal, or will indicate that the case is pending dismissal.
Well, the dismissal that we sent to him has some special provision in the order, some language. So I'd like to at least give him an opportunity to review it and get it back to us if he wants to pursue, to go in that direction.
Sounds good. All right, I will grant your request, and I'll set the matter over 30 days hence, and that will take us to the 18th. Sketch right at the 17th of June.
You're up and ready?
That will take us to the 17th of June. I don't know if she's still having a problem. I'm good. We're good here. So June 17th at 9:30 a.m.
9:30. Okay, thank you, Your Honor.
All right, thank you, counsel.
Have a good day.
Good day to you.
August 2020.
All right, the court now calls case number 19-153-538. This is Credit Corporation Solutions Incorporated versus Kendra White. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case on the 31st of May of 2019. That judgment balance or total at the time was $3,874.43. Subsequent to that time, there was a notice of judgment lien filed as well. Your appearance regarding this matter for the plaintiff.
Good morning, Your Honor. Navjot Francis on behalf of plaintiffs attorney of record B72322.
All right, and good morning to you, and thank you for your appearance for the defendant or garnishee defendant. Any appearance at this time? I'm looking for either Kendra White or I'm looking for someone representing the Detroit Public Schools Community District. Anyone on this matter? Oh, I'm seeing.
Yes.
All right. What is your name, ma'am?
Kendra White.
All right. Thank you, Ms. White. Ms. White, you work for the Detroit Public School Community District. Is that correct, ma'am?
Correct.
All right. All right. This is a writ of garnishment, of course, in relationship to a judgment that was previously entered as against you. And you filed your objections, indicated that you only got notice from DPS in February and was not properly notified or served on this debt. You indicate that you don't owe the amount. So, ma'am, there has already been a judgment that has been entered in this matter, and findings have already been made on this case. You would have to proceed by way filing a motion to set that judgment aside if you believe that a judgment should not have been entered against you. But there is a judgment entered. There's also a proof of service document that was the basis for entry of that judgment. That proof of service document says that the complaint was served on you on the 27th of April 2019 on Press Street in the city of Detroit. Subsequent to that time, the court granted entry of the judgment by default when there was not a response to the complaint. That's the history of this case, Ms. White, and that's why you have the garnishment that's been brought has been based upon a judgment that was entered back in 2019. Let me hear from Ms. Francis. What do you wish to say at this time, and then I'll come back to you, Ms. White.
Your Honor, it looks like this was previously adjourned to allow defendant to file a motion to set aside the default, which it does look like she did file one.
Let me stop you for a minute.
Yeah.
Ms. Francis, for some reason, your sound is very, very distorted. And I'm not able to make out fully what you're saying. So I don't know if you need to make some adjustments, but let me hear you now. Let's see if it's better.
Is that better, Judge?
That's perfect. So, wherever you get, do that. All right. Go ahead, ma'am.
Sorry, Your Honor. This was previously adjourned to allow defendant to file a motion to set aside the default judgment. It looks like defendant did file her motion. However, I would point out that defendant's motion does not state a meritorious defense. And as you stated, defendant was personally served on this in 2019 by personal service, and default judgment was entered in May of 2019. So this motion filed would not be timely, and it does not meet the court rules to have the judgment set aside. We do have a bill attached to our response to defendant's motion showing this was an art band credit card owned by defendant. So, Your Honor, sorry, that was attached to our complaint, not to our response. So, Your Honor, defendant has not met the court rules to set aside the judgment, and defendant's objections to garnishment should also be denied, as she has not stated a valid objection under the court rules.
All right. I do have the defendant's answer to the motion to set aside the default. I do not have that. I do not have the motion. For some reason, that is not in the court's file. So, Ms. White, on what basis do you believe that the judgment should be set aside? And obviously, there are two prongs. One is that there has to be a showing of good cause to set it aside, and also there has to be a showing of a meritorious defense. Those are two requirements under the applicable court rule concerning motions to set aside a default judgment. So give me give me what you believe is a basis to set aside the judgment, ma'am.
Of course. Yeah, I uploaded my license describing my description. I was never served, and I was only notified through my employer. That's why I filed a judgment to set aside. I have the paperwork for that. I'm 5'8.5", brown hair, white, 285 pounds, brown and gray hair. The description from the last court, I was told he served, or a person served a African-American, 240 pounds, 5'5", black hair. And my address is 511 West Cass Street, Greenville, Michigan. I also uploaded public records stating and showing my home ownership all the way back to 2012 and bills that went up through this time period that I supposedly was served. I don't know exactly anything other than the paperwork that says April 27th, personally served. And I did call the courthouse to ask about it. It's not my debt on another note, but I'm going specifically, I was never notified. I don't have anything on my credit. I don't have anything that was in my mail. I don't have anything that was served personally to me.
All right, so have you ever lived at the address on Press Street, ma'am?
I did. I didn't stay there. I only had it for a little bit and I got rid of it.
All
It was-
right, you said, let me stop you. So you said you never lived at that address?
No, I did live there, but I got rid of it. And I also have been at my home. And if I look up the 27th of Saturday.
Gotcha, but let me have you focus on my question, okay? So when did you live at the Press address?
It was, I rented for, not during this time period, prior. And I'm not quite sure the exact dates, but it was temporary. And it was a rental looking for other homes.
All right, gotcha, man. All right, just one moment, ma'am.
Yep.
All right, ma'am, I have a document that is attached to the complaint that was filed in this matter. And it makes reference to you allegedly you having a card with Art Van, GE Capital Retail Bank. You know
Never.
anything about- I'm
I
sorry?
know nothing, zero. I've never had a card for Art Van. I knew anything about it. The only time I found out was through this last court hearing, because I asked what the debt was.
All right, ma'am. And have you ever lived in Greenville, Michigan?
Yeah, I lived there since 2012, still am here, haven't left my house forever.
All right.
That's the address I have, 511 West Cass Street.
Got you. All right.
Also, I know personally I wasn't served. I was wondering if the person who served can identify me, because my last understanding was it was the African-American with black hair that was like 4 or 5 inches shorter than I am.
Well, it seems to me that you mentioned that to me already, so I'm trying to figure out why you're repeating that.
I'm wondering if they can identify. Is there someone here to identify me?
It seems to me like you said that about 2 or 3 times now, and I'm still wondering why you're repeating that.
You asked me why
I didn't ask you that. I asked you about that earlier. I don't know why you feel the need to say that 6 times. You don't have to, ma'am. I've already heard that part. I'm I'm inquiring into the other part of the prong now, and that's whether or not there is a meritorious defense to the claim. The document that I'm looking at indicates your address, and it indicates a indebtedness that dates back to 2013. And you indicate that you don't know anything about that.
I do not. I do not have anything. I went after this court date and looked for anything on my credit, anything, any mail, anywhere. I can't find anything.
All right, thank you. Ms. Francis, in light of those things, anything further at this time?
Judge, I would just again point to the statement attached. It does show that this was, statements were regularly mailed to defendant's address that she has testified that she did live at that time.
I'm sorry. You said
I'm sorry.
testify. You said someone to testify.
Defendant stated just previously in her testimony that she does live at the 511 West Cass Street address and has lived there and did live there, I believe she said at that time in 2013. So Your Honor, this is defendant's debt. She has not again stated a meritorious defense. So her motion is not timely, so we would ask for it to be denied.
All right. Just
And
one more.
sorry if you're having issue. I don't know what's going on with my sound. I apologize,
That's okay.
Judge.
I think it's the relative position that it has to where you speak into the microphone. Just one moment.
And Your Honor, can I have clarification when you're finished, please?
No, go ahead. What do you want to clarify, ma'am?
Well, I said during the time that April 27, I don't know what she means because I know I was not served. She says that it's my debt, but in the timely manner. If I don't know about the debt, how am I supposed to respond to it? That's my only question, I guess, is I don't know of it and I was not served. And how am I supposed to respond in a timely manner? I responded as soon as my employer told me information. I called, I said, what is this about? So I was, as far as I was notified, I was able to respond immediately. And I've followed up since I was notified.
Thank you, ma'am.
Judge, if I may, I'm not sure if this was included in our response, but we do have a property assessment record, which does show the defendant did own the property at 16884 Press Street.
That's false. I've never owned a home, ever.
I guess
this
what you're,
home.
all right. So, Ms. White has already indicated that she lived at that location at one time. You're saying that you have something showing that she owned the property?
It's yes, a property assessment record. It states the owner's name is Kendra White. States her property address as 511 West Cass and the owner address as 16884 Press Street.
All right. So,
Can I have clarification on that statement as well?
not yet. Not yet.
Okay.
So I'm looking at the answer to the motion now. I don't see an attachment in that regard, Madam Counsel, to your motion, to your response.
I believe because it's a Lexus Accurate record, I don't believe it was attached because of the redactions and.
Thank you, ma'am. What of the description given by your process server? I was not a part of that particular statement. What was there a time when the process server gave some statement regarding who he served?
I believe on the proof of service, it states it looks like he did write Black female. He wrote 40 to 42, 5'6", and 190 pounds and black hair.
All right. Yeah, and I do see that at the bottom of the document. To the best of your knowledge, Madam Counsel, does Ms. White seem to fit that description?
I cannot state how tall or how much she weighs, Judge, because we are on Zoom. She is not a Black female. I believe our process server was supposed to be on today. I'm not sure if that's him raising his hand on Zoom.
Are you here? If you're here, you can say something at this time.
I'm not sure if that's someone else.
All right. Yeah, I have other people on the Zoom. I see someone at the top there. Are you the process server, Minzer? Raise your hand if that's you. All right. So why don't you unmute yourself so that I can hear you, sir? You have to push *8 on your phone. Or *6. *6, I think it is. *6 on your device should unmute you, sir.
Okay, you can hear me now, sir?
Yes, sir. What's your name, sir?
My name is Darius Walker. I'm actually here for a court date. A Zoom
Are you
court.
on this? Are you on the case that I'm talking about now?
No, sir.
Well, why you raise your hand when I asked if you're the process server?
No, I raised my hand way before this started, sir. I couldn't hear you. I never used this before, so I couldn't hear you. So I was trying to figure out how it works.
I'm not.
All right, you thought you were in church. Okay, go on and mute yourself for a little while. I'll come back to you in a minute. I'm dealing with this particular case that's in front of me right now. All right.
Okay, sir. Yes, sir.
He thought he was at church or at a
He's in a concert. I mean, concert.
Did you
Lord,
my
he's in the wrong.
my court clerk said you were wrong.
Excuse me?
No, he's in the wrong courtroom, I believe. I think does he want mechanical?
Are you looking for Judge McConigal?
Say that
I
again.
don't got time.
You're looking for Judge McConigal, correct?
Yes, sir. Yeah, but I was told to put this number in, ID number.
You're at the wrong spot. This is the good-looking judge. I'm gonna send you to somebody that don't look as good as me. But that'll
Okay,
be
sir.
right. All right. And
All right.
maybe at the rap concert too.
Yeah.
But no, we're gonna give you a number to go so you can zoom into the correct courtroom, okay?
Okay.
So it's
Excuse me, sir.
360-533-0000. So you putting in 538, put in 533.
Yeah.
Okay,
those
so
middle-
533.
Three numbers. Yeah, just change those middle three numbers to 533.
Okay, thank you.
Okay, I wish you well, sir. All the best to you.
All right, thank you.
All right, so
Excuse
back
me.
to the subjects.
Excuse me, Your Honor. I was in a.
Yes. Who are you?
You see this shit?
Go ahead, sir. What's your name?
I don't give a fuck, bro.
Huh?
Fuck nigga act like this.
Come on, you gotta tell me your name.
Excuse me, Your Honor.
I already excused you. What's your name?
Oh no, I'm not supposed to. My name is Jaru Carson. I'm not supposed to be in this courtroom. I got logged out of the order of the courtroom as I was in there. My phone died because the lady wasn't. And then now I'm trying to get back in there and saying that it's locked. So I can't. I'm trying to see what do I do.
Okay.
Just tell him to call the clerk, 965. Can you call the clerk down there at 533-313-965-3953?
965-3953.
965-3953.
That's
Yeah.
right. 3953. 965.
3953.
Yeah.
Yep.
Thank you.
965-3953. Got it? All right. I wish you well now. All right, ladies and gentlemen, pardon the interruptions in regard to this matter. It would be significant to the court to have some input from the process server that could tell me straight up whether or not he served this particular defendant and can identify why he would put the particular description that he put on this document. And quite frankly, from the Zoom, I can't tell whether Ms. White is white, African American, or Hispanic. I don't know which one. And moreover, those are not key issues, but for some reason, the process server put black female, and I want to know the reason why he drew that conclusion. And he also had some other identifying information. That is a significant predicate. And so I'll order that person appear so that I can hear from the process server as it relates to as it relates to the motion to set aside the default. The court will take it under advisement at this point because there is a predicate, number one, that shows that a person was served, that person is identified as Ms. White, and that gives a presumption of service, but that presumption is rebuttable. Ms. White says that she was not served, or moreover, she says the description does not fit her. Those two issues are issues that can be resolved by the testimony of Mr. Mercer, the process service that's identified in this matter. And secondarily, there is a predicate to the lawsuit, which is a bill generated by Artvan that shows Ms. White's name and address and other information regarding indebtedness. That too is rebuttable, but we can't even get to that issue until we can resolve an issue that may have arisen as it relates to the identification of the process server. So I raised both of those issues because that's what the court rule requires. Court rule requires good cause, and it requires a meritorious defense. Those are legal terminologies that have separate significance. And so I'm going to set a date for the process server to come in. So I will set.
Excuse me, Your Honor, can I ask something before you do that? Because can I please?
Yeah, hurry up.
Because last week, the last time we were on, they said you must, that was part of this whole hearing, is that server would come and identify me. They dropped the ball on their part, and they were not prepared because I was waiting to see who served me.
They stopped you
I
for a
want to know
moment.
who served me, and I could prove my weight and height.
Oh, okay. All right. If I make the ruling on it today, then the judgment stays in place. You want to hear from that person just like I do. I believe they may have some good information for us. And that person is critical to this process. Now, there was another judge here on the last occasion, and I'm sure that they required that person come in. I don't see where there was a court order for that person to appear. I'm issuing an order for that individual to appear. And obviously, if they do not appear under my order, then that would mean that I would likely set aside the default and dismiss the case. So the next date is 2 weeks hence. And I'm ordering that person appear in the Zoom on the, what's that date?
You want to do the 5th today, which is Friday, the next day. You have June 1st.
Yeah, that would be the 2nd.
Huh? Second.
June 2nd.
Okay.
That work okay?
Mhm.
All right, so I'm gonna set it over for June 2nd, and I'll set it for 9:30. Let's set it for 10 o'clock. June 2nd at 10 o'clock a.m. So Madam Counsel, you're gonna have to get that person in, otherwise that's gonna be determinative of the case. And being able to hear from that person also may determine the case one way or the other, nonetheless. So that is a critical part of this matter. There is a colorable issue that has been raised as to whether or not this is the person that was served, and the court would need sufficient information to draw a conclusion in that regard. So the 2nd of June at 10 o'clock a.m. will be the time that I'll visit this for that specific issue of inquiring regarding the identification issue on the process, on the servicing process. All right?
Thank
So
you, Judge.
Excuse me, Your Honor, one more thing, please.
Yeah, go ahead.
It was my understanding that the lawyer that was with us last time was the person who personally served me, and he didn't say anything last time, and he didn't show up this time. And then on top of that, when I called
Let me stop
court,
before you talk yourself into my judicial frustration.
Okay.
I wish that I wish that I could put a go back button and be sitting there at the last hearing. I'm good, but I ain't that good. I'm just not that good. Really. And I've been a judge 29 years. I'm just not that good. All right. Now, you raised a significant issue. I don't like to waste time. I have a lot of stuff to do. You raised a significant issue, and you probably want me to get at that issue. You probably do. If you keep going on and on about it today, I have to make a ruling on it today. You don't want me to do that.
No,
All right?
I understand, Your Honor. I do.
Yeah.
I do, but
You
it's
don't want
frustrating to
do
me.
that. I think you raised a significant issue. Now, whether that's absolutely true or not, I'll know it at the next hearing. If the person doesn't show up, then the case is dismissed. They show up, I get a chance to make an inquiry, and you'll be here, and let me see what they have to say. And,
Yes,
and
Your
that will have a lot to do with what happens to this case. Or we can talk about it a little bit longer today. I just don't see where that's going.
Your Honor,
that's not-
I understand. Thank you. Thank you.
That's just not going anywhere. All right. Fortunately, you have not had to come down to the court building. This is one of the beautiful things about Zoom. You've not had to come down and you sit down and park your car and so on and so forth. So dial that number up. Come right back into here. 538 is the number now. I think the last time you were dealing with, was it 533 or something?
Yeah.
Well, you got the correct Zoom number. And come back into this. I'll be here on the 2nd, 10 o'clock a.m. And let's drill down on this and find out exactly what's going on. Okay? I wish you well. All right.
Yes.
Ms. Francis, I wish you well. I'll see you at that time, if not before, ma'am. All right.
Thank you,
Good day
Judge.
to you.
All right. I appreciate it. Thank you, Your Honor.
Thank you. Good day.
Such a lot.
And Counsel, Mr. Moscati, I don't see your matter in front of me. What do I have?
Your Honor, I'm just double checking to make sure that you don't have Midtown or Detroit Propco v. Ellis Kemp, number 21344-326.
We're checking on.
2 and 3, what?
One more time, 21344-326.
326.
That's Judge Brew's case. He should have been down in 432.
Oh,
Okay. Thank you.
432.
That's all I needed to know. Thank you.
Sorry about that, sir. Would have got to you sooner. All right, good
Have a
day
good
to you.
day. Sorry, folks. I'm in multiple courtrooms at the same time. I've got 3 devices going at the same time, and I'm trying to
Mr. Weiner, Arnold, are you have something in front of me, sir? Oh, he's not properly connected. Good. So.
Wow. Yeah. I'll be able to say, Deborah. It's the first time being able to really say something to her. This doggone thing been messed up.
She ain't answered.
I'm here.
Pick up.
I'm here.
They just shouldn't have touched that thing. Everybody in the courtrooms acting crazy.
Yeah, they should have, because it's never taken that long, you know. How come I'm not, can y'all hear me? Oh, you can't see me,
What'd you
huh?
say?
No, so you can't see me, huh? Where am I? Oh, there I am.
Oh, no, I see
That's
you.
so dark. See, I'm using my writer, and my writer taking up my plug.
Okay.
So I can't plug in my lamp.
All right.
But I'm here. I'm just trying to stay quiet. Yeah, they messed up everybody's Zoom.
Yeah,
A court
I kinda
reporter
figured.
texted me. A court reporter texted me saying they weren't on yet either. I'm sure they all by now. It's 11 o'clock. I wonder if that lady telling us.
I think so. Let me get off of the Zoom.
Yeah.